Okay, great. So we can get started. Good morning, everyone, and welcome to the final debate. I am your host, Ashley Mangar, Chair of the Academic Relations for ISACA New York chapter. Um, Assisting me in today's competition is Eugene Levin, who is the founder and my co-chair for ISACA New York Metropolitan Chapter, as well as Ikram Malik, who is the assistant director for the Academic Relations Committee at the ISACA New York Metropolitan Chapter. I hope you guys have a wonderful Sunday morning, and I'm so thankful that you're all here joining us for the final debate between solar eclipse and team code breakers. Now, there are some few housekeeping rules before we continue on. First and foremost, we would like to ask everyone to please mute your mic at this time. And if you are not one of the presenters, I would also like to ask you to please have your cameras off, so that way we give the spotlight to Team Eclipse and to Team Code Breakers, as well as to our judges. And if it is your time to speak, please definitely unmute your mic to ask your question. Otherwise, to everyone else, please refrain from using the mic and your camera. We would also like to ask you, the audience who is just viewing today's competition, to please refrain from using the chat feature. I know it'll be great to connect with everyone and to actually message everybody here, but it will be a type of distraction to our present presenters for today's session. So if we can just refrain from using the chat feature for today, that'll be amazing. Um, just to let everyone else know as well too, this session is being recorded, and we will be sharing the recording after it is ready for us to be shared. Okay. Now to introduce our judges for today. The judges are Radhika, and I do apologize for mispronouncing everybody's last name, Radhika Bajpai, Stephen Hotchberg, David Chang, Barry Dinkin, Tim Mortimer, Alex Bazay, Nitin Sharp, Neil Kirshner, Gehan Dabari, Christina Cruz, and Japneet Kaur. Now, without further ado, let's go into today's schedule for the final debate. The debate is going to last approximately 1 hour. Team A is going to first make the favor of the SEC case for 10 minutes, and then Team B is going to make the favor as well too for 10 minutes. Then we will have a 10-minute break, and then we will go back, and Team B is going to start making the case against the SEC case, and same thing, Team A will follow up for 10 minutes. Then we will have another 10-minute break. Then we will have Team B, they're going to answer the judge's question, and Team A is going to answer the judge's question as well too. And then that will conclude today's session. Okay? So if we can get started, Team A, we would like you to go ahead and start making the case in favor for SEC. And you will have 10 minutes on the timer. Sam, if we can get the timer started.
Sure, the timer starts now.
Hi, everyone. So in favor of the SEC winning the case against SolarWinds, the SEC, or the Securities Exchange Commission, exists to protect investors, to protect them from fraud. And that's the true essence of this case. The SEC alleges that SolarWinds committed fraud by intentionally misrepresenting their cybersecurity posture and the strength of their internal controls. Now, the issue isn't that they did so, the issue is that they lied about it. And that's where the SEC gets involved. The SEC alleges that SolarWinds committed fraud on their 8K, S1, and S8 reports, as well as on their security statement on their website. To talk more about the 8K form, I'll pass it to my teammate Hamza.
I appreciate it, Dylan. I actually think that Moshe is better equipped to handle the 8K.
Sure. Thanks, Hamza. In the SolarWinds 8K, SolarWinds said that the Sunburst breach was hypothetical, when in reality, it had already happened and they had already known about it because it had affected some of their clients. Additionally, it's improper to have firms like SolarWinds making generic security statements like the one on their website, when in fact they don't really have great security at all. Additionally, the SEC revealed evidence in their complaint that some of SolarWinds' internal communications revealed that employees were openly joking about how bad SolarWinds' security was. And in fact, one of their InfoSec employees had literally written, "Oh, whoops, I had just lied," when talking to one of the SolarWinds customers about SolarWinds security. And with that, I will pass it back to Alex.
Hi, everyone. I'd like to point out that, first of all, if a firm lies and gets away with lying, other firms will also lie, and this creates an environment that is fostered with unethical behavior. Investors rely on accurate and transparent information. When companies deceive, it distorts market dynamics and ruins fairness and transparency in which markets are built upon. The general rule is that in order for markets to function, they depend on accurate information. Fraud won't allow for a healthy market environment. I'll pass it on to Hamza to talk about corporate accountability.
Thank you, Alex. Building on Alex's point, increasing the level of transparency between companies and their filings with the SEC serves to increase investor confidence in the countries. It also makes it more likely that if companies need to share security information with the SEC and with its investors, that they will make an extra effort to be more compliant and to improve their security posture to look better overall as a company. Additionally, holding CISOs accountable also serves to improve security because CISOs are held at a higher standard. In the case of CFOs, if there's a fraud case, if there's a corruption case, the CFO can be held personally liable. So in this case, it would make sense to also incorporate CISOs into the equation with the breach because they're ultimately responsible for it, right? They get the corner office, they get the salary, but that also comes with the added responsibility that, you know, everything is under their watch and they need to know what's going on. I'll pass it on to Maria.
Thank you, Hamza. So emphasizing that point, executives within SolarWinds were entrusted with the well-being of the organization and still failed to fulfill their responsibilities. Executives such as CISO Brown should be held accountable for cybersecurity failures to prevent future breaches and uphold trust. Furthermore, the SolarWinds breach was not merely a failure of executive responsibility. It was also a failure of systemic collaboration and communication. Had there been improved collaboration between boards of directors, SolarWinds vulnerabilities would have been identified and addressed sooner, potentially mitigating the impact of the breach. I'll pass it on to Rosa.
5 minutes.
Rosa, you're on mute.
Sorry about that. Thank you, Maria. I'd like to highlight the protection of shareholders. Proper oversight and reinforcement by the SEC protects shareholders from financial losses and from fraudulent activities. By holding SolarWinds accountable for their actions, the SEC protects the interests of shareholders that rely on accurate disclosures to make informed decisions. The Securities Law Act of 1933 and 1934 were inspired by the stock market crash of 1929, which taught us that transparency protects investors. Therefore, Congress passes these acts to require companies to inform investors of the facts concerning securities and to protect them against fraud and misrepresentation. Now, I'd like to pass it over to Dylan to summarize the points we just discussed.
So to tie all those points back together with all the points that my team has made, what's in question here is, did SolarWinds knowingly misrepresent all of their controls and knowingly commit fraud against their investors? And the evidence suggests that they did. Therefore, in this argument, we believe that the SEC should win the case against SolarWinds. Thank you.
All right, thank you, Team Codebreakers. Next, we will ask Team Solar Eclipse to make the case in favor of the SEC. And Sam, give us the countdown for when the timer will begin, please.
Sure, and the timer starts now.
Good
Thank you.
morning, esteemed judges, respected opponents, and all the audiences present today. My name is Tam Nguyen. I'm honored today to represent my team Solar Eclipse in discussing the significance of the Securities and Exchange Commission's actions in the SolarWinds case. Before we begin, I want to acknowledge the codebreakers for their impressive presentation. They certainly set a high bar and were eager to engage with their points. To start up, the Securities and Exchange Commission, the SEC, was established by the U.S. Securities Act after the stock market crash to protect investors. Our roles have been evolving for the past 90 years to protecting finances managed on computers and cybersecurity disclosure as the records are now stored digitally. As we all know, the nationwide supply chain attack involving SolarWinds happened in 2020, and as the company has made tremendous effort to investigate and remediate after the attack, they received the Wells notice from the SEC 2.5 years later. The notice indicates that SEC may bring a civil action against a person or firm and give that person or firm the opportunity to provide information as to why the enforcement should not be brought. Then the SolarWinds filings was made official on October 30th, 2023. This lawsuit is notable because this is the first scientific fraud action and the first litigated action involving cybersecurity disclosure. Prior to SolarWinds filing, the SEC had never charged a public company and its CISO for scientific-based fraud charges and internal control failure. To explain more, for a scientific-based charge, a plaintiff must allege with particularity that the defendant had an actual intent to deceive, manipulate, or defraud. And now we'd like to go over major SEC allegations against SolarWinds with my teammate, Oksana.
Thank you, Tam. As well, as we are all aware that some of the points may be repetitive, we'll go over them briefly again with some extra points that are the decisive proof of this argument. I want to highlight two irrefutable pieces of evidence of security laws being violated. Actual evidence that internal employees knew of the red flags prior to the attack, and SolarWinds' deliberate omission of findings about the Department of Justice attack in May 2020 in the 8K after the December attack. Now I'm going to focus on these 2 points. Let's review evidence supporting the charges against SolarWinds and Brown for misleading public disclosures about cybersecurity practices. According to the Wired article in May 2020, the Department of Justice discovered hackers' operations potentially exploiting Orion software vulnerabilities and breaching the server directly. Despite communication, SolarWinds engineers failed to identify vulnerabilities in their code. Communication ceased by July 2020, with the situation being unresolved. Next, it was revealed the vulnerability indeed existed in the software's build system, an unacceptable oversight by SolarWinds at the time. Worse, when a SolarWinds employee was questioned about a similar activity following a cybersecurity firm's breach, they knowingly lied and even admitted to it in a message to a colleague, quote, "Well, I just lied." This includes that employees were fully aware that they were deceiving customers about Orion's vulnerability discovery. However, the company chose to not include the detail in the following 10K filings. We consider these specifics to strongly support the scientific-based fraudulent charge. The blatant statement, "Well, I just lied," by the employee and the company's refusal to include the red flags incident goes against the detail in SolarWinds 8K on December 14th, 2020. Despite claiming in the form that the attack could potentially allow data compromise, SolarWinds obviously knew hackers had breached their servers since May 2020. Next, we want to discuss password security issues. Just to remind, a 2019 internal audit found that critical systems did not comply with password policies and used and stored passwords in a highly insecure fashion. Additionally, we want to add one less obvious point. The 2019 alert to SolarWinds about a publicly available password for critical server allowing potential software infections highlights a severe security oversight. Security researcher Vinod Kumar claimed in his Twitter post that SolarWinds had been exposing FTP credentials to the download server, likely referring to the SolarWinds server that hosts software updates and downloads for their products and customers since at least 2018. In 2019, he alerted the company that anyone could access their update server using a shockingly simple password, SolarWinds123. Kumar even said This could have been done by any attacker easily. And another major point that we'd like to support is the secure development lifecycle, or SDL, deficiencies. A January 2018 email exposed that SolarWinds security statement's SDL section was false. Instead of amending it, SolarWinds planned to conceal the falsity and work towards making them true eventually. Presentations in 2019 and 20 highlighted inappropriate access controls and, quote, significant deficiencies. In 2020, parts of the Orion platform, the company's crown jewel, were still not developed under an SDL processes, which employees acknowledged as a problem. One employee stated, "The products are riddled and obviously have been for many years." Despite knowing about this risk and vulnerabilities, SolarWinds did not disclose them. While no software is perfect, strong vendors put processes and protocols in place to reduce the risk and deal with the threats. And most importantly, publish those security protocols for evaluation against upheld standards. In the February 2024 amended complaint, sources confirmed to the SEC staff that a large software company's failure to follow SDL would be an important fact in evaluating the company's stock. We also covered a few key points on access control failures. SolarWinds allegedly failed to enforce the least privilege system, where permissions are granted on a role-based model instead of given full administrative access. Only 2 out of 43 necessary NIST access controls were in place, with the CISO noting critical flaws in system access controls in 2019 and 20. Despite warnings in 2018 about critical VPN vulnerability, the CISO didn't act, allowing hackers to exploit it. A March 2020 email and quarterly risk review drafted with input from Brown and shared with SolarWinds C-suite executives described findings from SolarWinds SOX audit of internal controls. That included, quote, SOX control deficiencies, namely, quote, password requirements were not met. Yet no actions were taken regarding this issue. As passwords are fundamental to cybersecurity, serious deficiencies indicate systematic issue in how SolarWinds manage access controls. SolarWinds misled investors about their NIST framework compliance as well, as they had only 6% of NIST 853 in place as of September 2019. We'd like to make a strong case in this chart by bringing up 2 important points. NIST 853 is a comprehensive framework established to guide federal agencies in securing their information systems. While it's not mandatory for private companies to comply with NIST standards, given SolarWinds' status as a public company serving 180,000 customers, investors and clients expect a high level of security. With only 6% of NIST 853 controls implemented, SolarWinds lack preparedness for cybersecurity threats, leaving them and their clients vulnerable to serve financial, legal, and reputational consequences. We also did our research on internal control failures charge. However, due to the restricted time, we'll be able to briefly cover this charge. SolarWinds' critical assets are its IT network, source code, and software products. SolarWinds is mandated to assure authorized access to their assets, yet the company failed to comply because it didn't adequately implement and comply with the NIST controls.
To sum up, why people may think that the SEC is overzealous, we think that the laws are the laws. False statement about security would have violated securities laws, even if SolarWinds hack hadn't happened. What the SEC is looking for is permanent injunctive relief, disgorgement with prejudgment interest, and civil penalties. In addition, SEC is also pursuing officer and director bar against SolarWinds CISO, Timothy Brown, which would prohibit him from acting as an officer or director for a public company in the future. The reason why SEC zeroes in on Timothy Brown is because the CISO is primarily responsible for SolarWinds' cybersecurity disclosure process compared to the other C-suite directors. This is justifiable because ensuring transparency is fundamental to ethical business conduct and maintaining the trust amongst customers, partners, and stakeholders in any types of business. And those are our allegations against the SolarWinds.
Awesome. Thank you so much, Team Solar Eclipse. Now we will dismiss into a 10-minute break. So everyone, you're free to get your coffee while we all take our break. Everyone, welcome back from your coffee break. Alrighty, so now we're on to the second session where Team B, which is Team Solar Eclipse, is going to make the case against SEC and to criticize Team A's argument. So, Team Solar Eclipse, please take it away. Yep, no problem.
Okay, so timer starts now.
All right.
Great.
My
Thank
name is
you.
Brandon. Oh, no problem. My name is Brandon Scott, and together with my teammate Brandon Graff, we're representing SolarWinds. Although Team Codebreakers made some great points, we respectfully disagree. According to the SEC, SolarWinds only met a small fraction of the cybersecurity controls laid out in the NIST cybersecurity framework. The evidence for this claim comes from a self-assessment done using the NIST 800-53, a stricter regulation used for government entities. If they're using stringent government standards for a company like SolarWinds, this doesn't really highlight the work that our company put into improving our cybersecurity posture. If they can't get their NIST correct, they're showing they don't know much about cybersecurity. We also had a maturity score of 3 out of 5 in 2019. Most companies in the United States are below a 3, and only the military has above a 3. This is an ongoing process to improve our cybersecurity posture, and since we went public in October of 2018, that's an amazing score to have, considering we underwent corporate restructuring and coming out with that kind of score. As far as the misleading reports, imagine being a small company like SolarWinds. You're suddenly caught in a cyber attack orchestrated by one of the most powerful entities, the Russian government. This wasn't just a hack, it was a sophisticated, multi-pronged attack with threat actors that are lurking within your system for years, planning out every move that they make, from the trial runs in the system, the dynamically generating C2 servers based on Windows registry keys to evade detection, cleaning out the log files to hide their tracks, 12 to 14 days before the activation for the malware. They even monitored for security software like Wireshark. This is an attack from a nation state. In 2016, the Pentagon stated that computer sabotage on this level constitutes an act of war. Transparency in the face of such an attack that's a luxury we couldn't afford at the time. Our emails were already compromised. In the spring of 2020, the FBI found out that our email was being monitored, and once the hackers saw the email, they pulled out Sunspot. They were more concerned with getting caught than being able to exfiltrate information. That's the kind of threat actor we're dealing with here. Think of the anxiety and fear that we face. Every email, monitored, tracked. It's like being a small fish in a giant pond filled with great white sharks. Was our response perfect? Probably not, but we were fighting for survival against an overwhelming force. We took the steps that we thought that were necessary at the time to mitigate the damage and protect our customers. Honestly, if anyone should be held accountable, it's the giants like Microsoft and VMware. They left gaping holes in their software like the CVE 2020-4006 vulnerability in VMware and the CVE 2020-0688 exploit, specifically targeting Microsoft Exchange Server with a CVSS score of 9.6. These vulnerabilities served as the very foothold that APT29 threat actors used to breach our systems. And this isn't just an isolated incident. Just look at the recent December 2023 hack of Hewlett-Packard. The same APT29 threat actors exploiting the same Microsoft Office 365 environment managed to stay hidden for months, mirroring the tactics that they used against us. Also, what about JetBrains, the creator of TeamCity, a build management software that was linked in opening the door to the APT? At the time, 78 out of 100 Fortune 100 companies used this software, and according to the Wall Street Journal, the government officials say 30% of businesses affected by this hack had nothing to do with Orion or SolarWinds. Microsoft also fell victim to this APT. In November 2023, their own Microsoft Exchange servers were compromised by the same threat actor again, who infiltrated executive accounts. They weren't notified until January of 2024. This pattern exposes a clear trend. Microsoft and companies like them have a long history of failing to learn from their security vulnerabilities, while we, a small company, were left scrambling to defend ourselves against a state-sponsored attack. These tech giants repeatedly leave their doors wide open to attack. Shouldn't they, the ones with the resources and expertise, be held to a higher standard? Instead of solely focused on punishing us, shouldn't the SEC and the government be demanding accountability from these industry leaders who consistently, time after time, leave the doors open for them? My teammate Brandon Graff is going to take over and go into more detail on our attempts to stay transparent.
Excellent points, Brandon. Our executive team were trying to be as transparent as possible during the SEC's investigation. We took action as soon as possible after the events. We contacted the government and law enforcement agencies, notified customers impacted quickly, worked continuously to find a resolution to the problem, thanks in part to FireEye's work. We brought industry experts like Mandiant, CrowdStrike, and DLA Piper. As soon as the hack occurred, that very weekend, we spent making things right. We were also under stress. doing this during the COVID-19 pandemic, and despite these roadblocks, we still managed to respond quickly and prioritize our stakeholders. Additionally, what we really need is more of a collaboration between private and companies, or between companies and the government. In a constantly changing environment, in order to prevent large-scale cyber attacks, we need the resources, knowledge, and cybersecurity experts that work for the government. However, this cannot be done without addressing the failures of numerous government agencies. First, the CISA, whose stated purpose is to defend against cyber threats and collaborate with industry to develop more secure and resilient defense practices, as well as provide information to relevant parties, made a big mistake regarding this attack. They missed a crucial opportunity to alert us of the numerous instances of similar attacks on corporations such as Microsoft, JetBrains, and VMware, as well as government agencies. This information would have proven to be helpful in the possible prevention and mitigation of this attack on our company. Chris Krebs, the former head of CISA, was fired and admitted that they failed in their response to the attack. Additionally, there's the fact that the head of US Cyber Command, Paul Nakasone, was also the head of the NSA. By doing this, there could have been a strain on the overall capabilities of the two agencies, as their head had to not only keep track of important intel for one crucial government agencies, but two. Paul Nakasone also stated that the attack could be seen as a declaration of war. In this case, there are many inconsistencies with the SEC's pursuit. First, they are only pursuing charges against our CISO. This begs the question as to why they aren't pursuing any other key figures. SOX requires that the CEO and CFO take the ultimate responsibility for disclosure failures of all kinds, yet they are only charging our CISO. Additionally, in the case against Joe Sullivan, who is the CFO for Uber, who admitted intentionally concealing the breach of Uber's information systems, he was only given a suspended sentence. We can't help but think that the SEC is trying to make a statement or even an example out of our CISO. As for the SEC's claims about our company failing to disclose internal control material weaknesses, Section 9A of the 10K must detail the company's evaluation of internal controls and the opinion of the auditor as to measure the accuracy of management's assessment. From 2020 through 2024, this showed no material weaknesses identified by either management or the auditor, PwC. Is the SEC questioning the work done by the independent auditors, PwC, one of the most prestigious accounting firms, in opining our work and the advice that our attorneys gave us? If so, why are they not on the stand with us? Why are we being singled out? Additionally, we worked with the DOJ for 3 months and our code was found to be clean. This was a material event that should have been disclosed. How were we supposed to tell the public something was wrong when there was nothing to tell from the code? Experts in the industry acknowledged that the last place they would have looked for the malicious code was the build process. FireEye found this almost as a last resort. The founder of Mandiant, Kevin Mandia, admitted that they only discovered this code by going down to the most basic framework of coding, assembly language. Another point we'd like to make is that the Supreme Court case pending this June regarding the appointment of SEC administrative court judges, this ruling will likely require the ALJ to be approved by the US Senate as required by the US Constitution. This will likely allow us to have a fair hearing in court, as well as to delay the onset of the case. For extra information, there was an amicus brief written by Paul Weiss on behalf of 20 of the most senior cybersecurity government officials in the US. It reads, "We urge the court to consider the risk of chilling voluntary disclosure by companies or CISOs who may become more hesitant to share with law enforcement preliminary information about a cybersecurity incident or vulnerability if that information may be treated in hindsight as something that should have been disclosed publicly." Additionally, Freshfields and co-counsel Cooley LLP filed an amicus brief in the SEC versus SolarWinds case, which was signed by 50 CISOs in support of us. And this is our team's defense for SolarWinds against the charges brought by the SEC. Due to time constraints, there are other points that can be made as well. However, these are the most important points. In the end, we think that the level of governance we provided was adequate.
Okay, thank you so much, Team Solar Eclipse, sorry. Alrighty, now it's time for Team Codebreakers to make the case against the SEC case and to criticize Team Solar Eclipse arguments. You guys have 10 minutes. Sam, please give us the countdown.
And the timer starts now.
In making the case in favor of SolarWinds against the SEC, it's important to acknowledge that the SEC is overstepping its authority by bringing charges to both SolarWinds as a firm and CISO Brown as an individual. Brown was acting in the capacity of an agent of SolarWinds in his position as CISO and should be held accountable accordingly. Another point is that the SEC is stepping outside of its bounds as a regulatory body, specifically a financial regulatory body. It's wandering outside of its scope of responsibility in an area where it's clearly not an expert, as we saw with its confusion over which framework SolarWinds was not compliant in. So, the SEC alleged that SolarWinds was not compliant in NIST 853, whereas SolarWinds claimed that they were following NIST CSF. A mistake in this level shows that the SEC is not a subject matter expert in cybersecurity and should not be opining on any company's cybersecurity state. Now I'll pass it to Hamza to discuss the chilling effect on leadership.
Thanks, Dylan. So one of the short and long-term impacts of this case would be that it could have a chilling effect on leadership. If Brown were to be charged successfully, it would make it so that other highly qualified individuals in the industry may not want to take roles as CISO with companies. If they know that a highly sophisticated attack like this one from a nation state backed actor could result in them being sued and charged personally, these individuals may not want to become CISOs, which could really result in major security issues for companies, since they would either not have CISOs or they would have unqualified individuals in those positions, which would only make matters worse for the industry. I'll pass it to Moshe. Thank you.
Thank you, Hamza. One interesting point that I want to make is that in this case, the SEC is establishing a brand new standard for public disclosures. Before this case, companies like SolarWinds were okay to make kind of generic disclosures in which they would say, oh, we are vulnerable to attacks from nation states, we are vulnerable to generic cyber attacks, and that was okay, and there was legal precedent for this. In this case, the SEC is establishing a new standard for an unprecedented standard for what is required in public disclosures. A core argument that SolarWinds is making in their motion to dismiss is that what more should they have said? They said in their disclosures that they are vulnerable to nation states. Should they have included, oh, we are vulnerable because of a bug in VMware, because of a bug in some zero-day exploit? If they had done that, that information is not very useful to investors who presumably are not subject matter experts on 0 days. But information like that is very useful to hackers. And requiring companies to put that kind of information in their public disclosures is just very bad cybersecurity practice, and it's counter to the aim of cybersecurity departments. And with that, I would like to pass this to Alex.
Thank you, Moshe. I'd like to point out that SolarWinds was victim of a highly sophisticated attack. It is unfair for the SEC to blame the victim, SolarWinds in this case, because SolarWinds didn't have the adequate controls to prevent such a hack. And after all, SolarWinds did say they're vulnerable to nation-state threat actors. Right now, I'd like to pass it on to Rosa to talk about the stock market.
Thank you, Alex. To Brandon Scott's point, if firms think that going public, doing an IPO, selling shares to public shareholders is too risky because of overly powerful regulators, then firms will continue to stay private rather than list the stock market. If firms never IPO, that limits some of the opportunities for average people to invest in those firms directly. And I'll pass it over to Maria.
5
Thank
minutes.
you, Rosa. I'd also like to add on that the SEC winning could lead to potentially stricter interpretations of regulations, which could cause additional costs for companies as they adapt to new requirements, and it may hinder cybersecurity innovation due to extreme caution over regulations and legal repercussions. Now I'll pass it on to Moshe.
Thanks, Maria. So for this point, I would like to respond to Team Solar Eclipse's initial presentation, which was great and well-spoken, but it failed on legal grounds. Team Solar Eclipse, and specifically Tam's initial point, focused on scienter, which is a legal requirement for charges of fraud that requires intent to defraud investors. The problem with using that argument as a basis in this debate is that a key portion of that argument was that on the internal communications of SolarWinds, there was an InfoSec employee who said that, whoops, I just lied. And he did lie, which is unethical. However, he lied to a customer, not an investor. His internal communications, and he was referring to him communicating with customers, that has nothing to do with the public disclosures that companies are required to make to the SEC. And the SEC is only able to prosecute those kinds of any sort of fraud in those kinds of disclosures because those disclosures are going to investors. So in this case, there was no scienter because there was no fraud to the investors. And with that, I would like to pass this back to Maria.
Thank you. Team Solar Eclipse also mentioned that SolarWinds did not fully comply with NIST 853. However, in SolarWinds' security statement, they said they followed the NIST cybersecurity framework, and they did. While the SEC referenced NIST SB 853, SolarWinds only claimed compliance with CSF. Furthermore, even NIST itself doesn't require firms to adopt every control objective. So they're not breaking the law by not fully meeting the framework. Now I'll pass it on to Dylan to wrap things up.
Thank you, Maria. So after this analysis with the SEC's scope creep as a financial regulator, the chilling effect on leadership, SolarWinds not lying on their financial and public disclosures, and SolarWinds being a victim of one of the most sophisticated cyber attacks in history, it's clear that SolarWinds should not be held liable for what the SEC is alleging and should win this case. Thank you.
Thank you so much, Team Codebreakers. And round of applause to all the teams that participated in today's competition. Now we will break into our second 10-minute break. So this is the perfect time for everybody to go get their snack and get some water before we come back. We will be back here at 11 o'clock. Hello, everyone. Welcome back from your 10-minute break. And now we're going to begin the judges' questions round. So first, we're going to start off with Team Solar Eclipse. We do have a judge that would like to ask you a question. Alex, may you please go ahead with your question? And you will have 3 minutes to answer.
Hi, everyone. Again, congratulations to be in the final round and good luck with everyone, to everyone. So we discussed this and judges have the different questions and we group them into a few bigger buckets. So the first round of questions that we have, it's a little bit more tactical ones. Assume the case goes to the court. What would you think Tim Brown and SolarWinds, what argument they should make to persuade the jury in their favor? That's the first part of the question. And the second part of the same questions, what do you think going forward, what piece of technology the SolarWinds and companies similar to SolarWinds should deploy going forward to at least mitigate of this type of events?
And we will start off with Team Solar Eclipse. Team Solar Eclipse, your go. Alex, if you could start, I'm sorry, Sam, if you could start the timer for us, please, for 3
The timer
minutes.
starts now.
Okay, so as far as the argument to make to get them on our favor or to get them on our side, the main argument is the failure of the government to, in order to prevent these large scale cyber attacks. And also what we did, I mean, as far as like holding other companies accountable like Microsoft and VMware, because it was their vulnerabilities that led to us being hacked in the first place. So I'd say those main two things. So as far as the technology that would be required to mitigate this, I'm going to pass this to Brandon Graff.
Okay, so I would say that they should increase the level of segmentation in their systems so that hackers cannot move bilaterally or laterally through the different portions of their systems. I would also say that they should constantly make sure of the identity of the user who's interacting with their system. Every time there should be a check, zero trust. And I also think that they need to have transfer completion tokens. Tokens are extremely important. I think that if they had these tokens being exchanged, they would be able to tell if hackers were intercepting any of their data that was being sent or processed. So that's what I think.
Okay. Any judges has any follow-up questions? Then we can move to the team. number 10.
Alrighty. So for Team Codebreakers, now the question is yours. Would you like Alex to repeat the question before we continue?
Yes, please.
Okay, Alex, may you please
Hi,
repeat the
Dylan.
question?
Yeah, so question is, if there goes to the court, what arguments SolarWinds and Tim Brown should make to persuade jury on their favor? That's the first part of the question. And the second part of the question is, going forward, what piece of technology the company similar to SolarWinds should deploy to make sure they're not going to be in the same position as a SolarWinds in this case?
Okay,
And
Team
I-
Codebreakers. Yep, go ahead, Sam.
Yeah, it starts now.
Go.
For the argument that SolarWinds and Brown should make in court, they should acknowledge that the SEC is known as a financial regulator, given their previous misunderstandings of the situation that SolarWinds is facing, and clearly showing that they're not a subject matter expert on anything that SolarWinds is currently facing, regarding how SolarWinds didn't lie on their disclosures and were the victims of one of the worst cybersecurity attacks in history. They should make those arguments showing that they should not be held liable in the way that the SEC is alleging. In terms of the technologies that they should be referencing and using, I'd like to pass it to Moshe or Hamza.
I can take that.
Sure.
Oh,
You go.
all right. And if I have anything I missed, you can take over. So as far as technology-wise, what SolarWinds and other companies like SolarWinds should be doing in order to prevent these kinds of hacks is, like Team Solar Eclipse mentioned, we need zero trust. We also need multi-factor authentication on everything, especially VPNs. There was some possibility that the initial attack vector for Sunburst was through a VPN, so VPNs need to be very carefully managed. You need segmented networks, so that includes something called VLANs. You need IP segmentation. You also need granular access controls, in which an administrator would only give very specific access to very specific users as needed. There's something also called just-in-time access, in which even an administrator won't have full admin privileges unless, except for the specific times that they need it. So there are a lot of technologies that can be used to mitigate attacks like this. And obviously, they really need to be very careful with their software build processes. And there's a lot of guidance in the NIST 161, which is about supply chain risk management that companies can be using. And I'll pass that to Hamza if he has anything left to add.
Sure. So I don't have anything to add to that question, but I will go back to the response that Dylan gave and talk a little bit more about that. I think it's also important to relay to the courts just how severe this attack was and how sophisticated it was in nature, right? These were Russian-backed hackers, right? These aren't script kiddies. These aren't elementary level hackers. They're extremely well-trained, extremely they have an extremely strong grasp of cybersecurity and hacking, and just letting the courts know that this was an extreme level threat that they faced. Thank you.
Thank you very much, Team Codebreakers. Alex, I do believe that we do have one more question that we would like to ask. And we would like to ask Team Code Breakers to go ahead and start this question. So, Alex, may you please ask the next question?
Absolutely. So the next questions we have is, as you were aware of, SEC released new requirements for cybersecurity breach disclosure and for the risk disclosure for the public companies that just came into effect. In initial draft of these regulations, SEC made the requirements for the public companies to appoint somebody with the cybersecurity expertise to the board of directors. It was a strong pushback from the companies in the comment period, and that provision was scrapped. So right now, SEC making a recommendation somebody with cybersecurity expertise to be on the board of directors. In your view, if that provision would stay, how would it affect the public companies? How would that affect how company operate? And how would that affect the role of CISO in the companies?
Sam, if you could give us the countdown for 3 minutes for Team Code Breakers, please.
Sure, the timer starts now.
Well, yeah, I can start us off. Involving more cybersecurity people on the board of directors would be a pro for the company and the industry as a whole. The board of directors, by its nature, should have a varied and of a diverse perspective on how the company should be run, on the actions that they should be taking for their stakeholders. I think Rosa might be able to talk a little bit more on this.
Yes, thank you, Dylan. We think this would be an positive impact, as somebody with a cybersecurity background would be able to assess the materiality of attacks and assess how to proceed with incident response and implement that or change accordingly. And I'll pass it over to Moshe or Maria.
I think it's a great idea. It's very important that someone on the C-suite who is responsible to investors be also capable of defending the company assets that help make the investors their money. And that's all I have to add. I can pass this to Maria if she has anything to add.
Actually, I'd like to jump in. Oh, Maria, you can go.
No, you can go ahead. Thank you, Hamza.
Okay. So I believe one of the pushbacks from the industry was that there weren't a ton of CISOs or C-suite level technology officers who companies believed to be qualified for board of director level positions because they didn't have a solid enough understanding of the financials, financial operations of companies. So I believe that this is a good step to take because it'll push for companies to develop their technology, their chiefs of technology, right? CTO, CIO, CISOs, to have a better understanding of financially how to run companies so that they can make informed decisions as members of the board. So Maria, if you have anything to add.
I believe that's all. I just think this will really strengthen cybersecurity practices within companies. Thank you.
Thank you very much, Team Code Breakers. And now we would like to ask Team Solar Eclipse to respond to the question. Alex, if you don't mind, may you please repeat the question for Team Solar Eclipse?
Yes, absolutely. So as you were aware of, SEC came out with new requirements for the publicly traded company in regards of disclosure of cybersecurity incidents and in regards of reporting of cybersecurity risk. In initial draft of the documents, SEC made the requirements for the companies, for public companies, to appoint somebody with the cybersecurity technology expertise to the level of the board of the companies. That position, that revision was dropped during the comment period, and right now SEC making this as a recommendation and not a requirements. If that initial provision would stay, how would you think it would affect current situation, and how did that affect industries going forward?
And the timer starts now.
Thank you, Mr. Alex. I'd like to take the the point and answer to your question. So one of the pros to this recommendation is the fact that, as mentioned in the SEC charge against SolarWinds, there was no clear communication between the CISO and the management board. And for that, for this change to happen, appointing somebody up with some level of IT to the board management would help regulate open communication in the event of a cyber attack. There'll be a more decisive actions and plan accordingly with all the board on the same mind. And the concept is that the hesitation of any CISO to step into the role, because after the changes are made in effect, the director in position must have the technical knowledge as well as the legal knowledge, and that is a lot. For a CISO, I think they should only focus on the technical experiences of their own. And because of that, the hesitation of the CISO to step into the role whenever there's an offer will mean that the industry is will not have many talents.
Okay, thank you. Any other comments from the team? Great. We do have a few minutes left. Any judges wants to make any comments, any questions they may ask? Yes, I guess. Thank you for your response. I think
Oh wait, we
okay,
do have Barry.
we have Barry.
Yeah, if we have time, I would ask another question. If you could elaborate a little more on generally what you think the implications of this enforcement action vis-a-vis the July 2023 issuance of the SEC guidance writ large might be. How do they juxtapose with each other? What might they mean, and what might either decision in this case mean for the future of that guidance and the future of the SEC's ability and practices to enforce cybersecurity disclosure requirements?
We will start with Team Solar Eclipse. So Team Solar Eclipse, you have time to answer this question.
Barry, do you mind repeating the question for us? Thank you.
Yeah, absolutely. So in July 2023, the SEC issued a circular with guidance as to the nature of disclosure requirements relating to cybersecurity governance, strategy, and disclosure requirements. What might the relevance of that be to this enforcement action, on one hand, and what might the relevance of a decision in either direction in this action mean for the future relevance of that guidance that was issued in July 2023?
Timer is on.
Thank you, Sam.
I think they zero in on the immediate disclosure in the event of the cyber attack, because in this digital transformation, cybersecurity is not a form of insurance. It means that it does not just ask for protection for companies' asset anymore, but it's also a strategy of growth. So if business want to grow in the future, they need to pay close attention to their cybersecurity management and risk management and disclosure protocols, making sure that transparency is on the top of their mind in the event of any attack happen.
I'd like to add also that in relation to transparency, this could also be a detriment to these companies, because if they are becoming more transparent, they would have to release even more information, and some of that information could be held in the hands of potential threats who can then use that information against these companies. and exploit what they found out.
Any more response from Team Solar Eclipse?
I think
All
that
right. Alrighty. So let's move on to Team Codebreakers. Barry, if you don't mind to repeat the question again for Team Codebreakers, that'll be great. Barry, you're on mute.
I am on mute. Thank you.
You're welcome.
If you could possibly elaborate on the relevance of the SEC's July 2023 circular with guidance on cybersecurity governance, strategy, and disclosure requirements, and its relevance to this enforcement action, and vice versa, the relevance that a result in either direction in this enforcement action might have on the future applicability of that guidance. Thank you.
Team Codebreakers, the floor is yours. Sam, if you could start the timer, please.
Timer starts now.
Right. Thank you for the question. I think with those new with the new developments regarding that, I know Moshe has been following the most up-to-date cases, the most up-to-date updates with this. So I'd like to pass it to Moshe if you'd like to take a stab at it.
Sure, Dylan. So, as far as I'm aware, the most recent developments in the case was the SolarWinds filed a motion to dismiss the case brought by the SEC. From what I read, I do not recall them even mentioning this new circular in their motion to dismiss. So I believe that this circular is probably irrelevant to the case due to it being released before the complaint was brought. I believe, although I could be wrong on the timeline, that is what I believe. And I'd like to pass this to Hamza if he has anything to add to that.
Sure. And as it comes to disclosure and transparency, I think that SolarWinds, after the breach, did an admirable job. I believe that SolarWinds came out and they said in their filings with the SEC that there was a possibility that 18,000 of their customers were possibly impacted. And that came at a cost to them and their reputation, because it turned out after they had done their investigation that only 100 were, less than 100 were actually impacted. So I believe that increasing transparency is important, both because it increases investor just overall and knowledge of what's going on with these cybersecurity companies as it relates to breaches. But it can also, as the previous team mentioned, give help to potential attackers who may know that, okay, maybe SolarWinds is vulnerable now, and we could target that. So I think it's a dual-edged sword, and it's a, and I'll pass it to Rosa if she has anything else to add.
Yes, Hamza. So to my knowledge, the July guidance report was what suggested that companies adopt or to disclose the materiality of incidents they experience, and then on an annual basis to inform their cybersecurity posture, including their risk management strategy and governance practices. And so I'd just like to highlight what materiality is. It's whether the information is relevant to a decision maker or an investor, shareholder. So I think in looking at the outlook of the action applicability in the thank you.
Okay, Rosa, you could go ahead. Continue on.
I was just thinking that applying this to future actions, it would be relevant to SolarWinds case.
Thank you. Great answers.
Okay. I think we are very close to time. So, judges and teams, thank you so much for participating in today's final debate. You guys did an amazing job. The judges are now going to be taking some time to actually think about today's debate, and then we'll be reviewing the scores and giving scores out. If you want to know who won the debate, I highly recommend for you all and to the rest of our audience to join us on May 23rd at our spring membership event at Markham Technologies, where you will find out who will be winning the final debate, the student competition for this year's ISACA event. And Eugene, am I missing anything else?
No, thank you very much, everybody, for participation. It's been a record year for us. We are so very proud of you, everybody, and the terrific job you've done. And you know, as soon as we determine the final placements, as a treasurer, I will issue the scholarships that you so rightfully deserved. And you know, we invite you to participate next year as well.
Awesome. All right, everyone. Enjoy the rest of your day, and we will see you on May 23rd. Thank you. Goodbye.
Thanks.
Thanks, everyone. Bye.
Bye.
Thank you.
Goodbye.
All righty, here we go. Good morning, everyone.
Good morning.
Good morning.
Good morning.
Good morning.
Morning.
Good morning.
Morning, everyone.
Morning.